All right, good morning, everyone. My name is Michelle Jacko, and I will be the moderator of this panel, which is the life cycle of an SEC examination. And I'm going to just begin with some general housekeeping about this particular session. Unlike some of your previous sessions, we do not have an iPad, and we are not going to have folks walk around with index cards given the intimate size of this room. So I just want to let you know, Marita can't, unless you're in the front row, she cannot read your name badge. So if you have questions, please raise your hand. We will entertain questions throughout. And if you could please mute your cell phones during the session, we truly appreciate it. So I'll begin with some introductions. And to my extreme left, or to your right, is Jackie Hummel, who is the managing partner and partner of Hardin Compliance Consulting. As a securities attorney and compliance consultant, she specializes in investment advisors, broker-dealers, investment company regulation, and compliance. Prior to this, Jackie was CCO at PNC Capital Advisors and PNC Realty Investors. And next to her is Marita Bartolini, who is the Assistant Director of OCIE at the SEC. She has over 20 years of examination experience and serves as an assistant director for OCIE's Home Office Investment Advisor and Investment Company Examination Program, assisting in the management of the group's 30 examiners. Next to me is Rick Marshall, who is a partner at Katten, Muchin, Rosenman, LLP, where he represents financial institutions and executives subject to investigations by the SEC, DOJ, FINRA, and state securities regulators. Prior to that, Rick was a former senior attorney at the SEC and was attorney at many other places. And then yours truly, I am the CEO and managing partner of Jacko Law Group and also CEO of Core Compliance and Legal Services, and we're a compliance consultation firm based out in the Golden State. I think what's so important about today's session and some of the matters we're going to be speaking about, let me actually go to the agenda here, is that the examination process is continuously evolving. So we're going to start with Marita walking us through the life cycle of an SEC examination and some of the things about OCIE's National Examination Program. And then Jackie's going to have an opportunity to talk to you about some practical tips for preparing. And then we're truly going to get to the heart of the presentation, which is to walk you through some case studies of what are some of the most common deficiencies that we're seeing in today's examinations. And then Rick's going to walk us through approaches in dealing with challenging scenarios, such as when to self-report. And then finally, I'll conclude the presentation with some practical tips on how you can use risk alerts to prepare for your next examination. So with that, I'm going to give the floor to Marita to walk us through this.
Thank you. Good morning. Before I begin, I need to give you the required disclaimer that my views I express here today are my own and do not necessarily represent those views of the Commission or its staff. I'm going to briefly go over 4 items today: the National Exam Program, how exam candidates are selected, what to expect during an exam, and how to interface with the exam staff. Here are some demographics about the National Exam Program as well as the registered investment advisor population. The exam program has 11 regional offices as well as the DC home office, with approximately 630 individuals who support the IACCP exam program. Compare that with 13,500 registered investment advisors with $84 trillion in assets under management. Of these advisors, 90% of the assets under management are managed by only 10% of these advisors. What this means is that the vast majority of advisors, about 60%, are smaller firms managing relatively small amounts of money, about $500 million. More than half of the advisors have 10 or fewer employees, and only 7% have 100 or more. Half of the advisors have custody of client assets, about a third have multiple offices, a third have managed private funds, and about 3% are also registered broker-dealers. Given these demographics, here are OCIE's FY19 IACCP exam program results. We examined 2,180 advisors, which is about 15% of the population. and we also examined over 150 registered investment companies. Most exams resulted in deficiency letters. Some result in no further action letters, and others became enforcement referrals. Many exams include asset verification, and certain exams resulted in recoveries for clients, such as advisory fees. So now let me ask you a question. How many of you here have had your firm examined? Oh, okay, so you're old hands. So did you ever wonder why your firm was selected? Okay, so I can give you a little bit of background. So the exam program is risk-based. I'm sure you've probably heard that. And the reason a firm can be selected, there are many, but I'll give you a few, but it's not limited to just that. First of all, your firm's risk profile. We could also receive a tip, complaint, or a referral. Or maybe we conduct an exam to review a particular compliance area. Or we might be conducting an exam to review the effectiveness of our risk-based selection process. And sometimes there's statutory mandates for an examination. The reason that your firm has been selected is non-public, and typically we don't share it. So how does the risk-based model mesh with the exam initiatives? Well, the risk-based exam selection process includes the identification of exam priorities, risk ranking, and the creation of an exam plan. TCRs also generate examinations, and those usually are acted on sooner rather than later in order to confirm the suspected wrongdoing. We also conduct exam initiatives, such as never before examined. And a firm would be examined not necessarily for a specific risk, but just the fact that it's never been examined. That's considered a risk. We also conduct exams to inform policy, and that means we're gathering information about maybe a particular new investment or a new practice in the industry. And again, some people view new practices, new instruments to be risk. And risk ranking, in OCIE we have an Office of Risk and Strategy, and within that group they have a Risk Analytics and Surveillance group. We call them RAS. RAS surveils data both internally as well as externally, and some of the external information that they review to put together a risk profile would be information filed with other regulators, SROs, exchanges, as well as information provided to third parties, such as about business activities or marketing efforts, such as performance. So based out of that information, RAS will generate a risk ranking. What can you expect during an exam? Will you be notified? Exams can either be announced or unannounced. So if the exam is not announced, that means the examiners are just going to arrive on site and they'll provide you with a document request letter. However, it's more than likely your exam will be announced. And how does that occur? Well, you're going to have an examiner call you, and they will announce the exam through that manner. And during that call, you'll find out whether it's going to be an on-site or a correspondence exam. After the call, you can expect to receive a document request letter. And during that request period, we ask that you provide documents electronically as well as a rolling production. We will develop an agenda for interviews, both for on-site as well as correspondence exams. During an on-site exam, we'll ask for a walkthrough of your premises. The interviews that we'll schedule will be a firm overview to start, as well as functional areas such as portfolio management, trading, marketing, financials, as well as compliance. We may ask for additional, more focused interviews after we review the documents, and we may have additional document requests. The staff will review corrective actions if you've been examined before from past deficiency letters. At the end of the on-site, we'll have an exit interview with you, but keep in mind it's preliminary because we'll still take the documents back to the office and have some further analysis and review. We may ask for clarification through additional phone calls, additional document requests. The issues will be vetted throughout the internal staff. A comment letter will be drafted, it'll be reviewed, and then approved. Then we'll set up the final exit interview with your firm. We'll discuss the comments in the letter, and then we will send it to you. We request that you respond back in writing, and then when we receive your response, we'll look at your response and review it for how you plan to address the issues noted in the comment letter. And lastly, how to interface with the staff. First, what makes an exam go smooth is to have a professional relationship with the examiners. Both examiners and registrant personnel, when they exhibit mutual respect, professionalism, and operate in a spirit of cooperation, really facilitates the exam process. Taking an adversarial approach only raises suspicions. Next, and very importantly, the point of contact that you assign to the exam team really needs to be knowledgeable. The exam will be expedited and it will go much faster and much smoother if the point of contact is knowledgeable about the firm and its business operations and is empowered to direct the firm personnel to respond to our requests for information as well as interviews. When the point of contact has little information, it just takes longer and the exams are less efficient. And most importantly, you need to communicate with the examiners. I can't say that more. If you get a request from an examiner, you don't know what it means, or it seems like it's voluminous, or it takes a lot of time, could be costly, please reach out and discuss it with the examiners, the exam manager, or even the assistant director, because it's much more important that we get on the same page to understand what we need and what you can provide, and then we don't waste resources both on your end and our end producing and reviewing the documents that turn out to be unresponsive. We also understand that the examiners, we're in a complex industry and that terms may be used that are different at different firms, so please feel free to make sure that we understand you and you understand us.
Marita, if I may, does it help, because as I'm listening to this, it sounds like what could be helpful is for folks to prepare that, what I call the opening ceremony presentation. Have you found that to be very helpful if folks are proactive with that?
Yes, very much so. It's very important. You think about it, our examiners come in and we need to understand your firm in a matter of days. And how long, when you started at your firm, how long did it take you to understand it? Probably a little bit more than a few days. So we're really under pressure. So whatever you can do to help us understand your firm better, we appreciate. And that's pretty much it.
Okay, fantastic. And for those of you in the back, there are plenty of seats up front, so don't be shy. Are there any questions for Marita before we go on to our next section? Yes, ma'am. Okay, for those of you that have never been before examined, the question is, what is the duration of time that may lapse between when basically somebody gets registered and to the point of when they're first examined by the staff?
So we take an approach where we would actually like to at least examine in a more focused review every firm that registers within 18 months. Obviously, our resources don't allow that, but we have what we call it the newly registered exam. So we call them NREs. And so we do try to do that, but if we don't get to your firm in that time frame, it may take a little bit longer, and then it'll convert into what we call a never before examined firm. And so that will have a larger scope.
Okay. Yes, sir.
How do you decide whether to do correspondence or on-site?
There are a lot of factors. It's really specific facts and circumstances. It may be the type of exam where we're just trying to gather information, maybe to inform policy, and it's very narrow, so correspondence may help that, or maybe we're trying to do a lot of firms, so correspondence may help. So it depends, or maybe it's a more in-depth or complex firm, so we would feel more comfortable going on site.
And I just want to clarify, for those of you, I believe everybody should know, but for those of you who might not have ever had a correspondent exam, that's an examination whereby it's through document request where the staff is not going on site. Okay? Anyone else? Yes, ma'am.
You have operations in different locations, so headquarters is in one place, but ops is somewhere else, and marketing is somewhere else. How do you decide where to go, and or is it a good idea to just bring in the people whenever you decide where you're going that you're going to need?
So we'll usually go to the main address that's listed in the form, ADV, but we'll confirm that with the firm. And then it may depend. So let's say your portfolio managers you're located in New York, but your portfolio managers are in Connecticut. And if the focus of the exam is on portfolio management and talking to the traders and portfolio managers that happen to be somewhere else, we may go there just because it's easier. So it is still facts and circumstances, but usually the main office.
Okay, final question. Yes. Okay, but just to repeat, for those of you that are new registrants, are those examinations typically correspondent or on-site?
Typically, the newly registered advisors are correspondence exams. They're more focused on compliance, welcome to regulation.
Okay. All right. Jackie, there's often a sense that one will become anxious. I don't want to use the word nervous. We'll just become a little anxious when they find out that the SEC will be arriving to their office. And I know that, through preparation, there will be a sense of calming that hopefully will be yielded. Could you walk us through some tips and preparations?
I think like most compliance professionals, I tend to be a little bit compulsive, and I do have some anxiety, and I know that part of the biggest thing is having a plan in place. Doing something certainly helps a lot. But what I've put in a lot of tips on how to prepare in this in the material, so I'm not going to go over these point by point. So if you just want to look at those, and there's also some materials to help you out as well. But I think the two biggest things that I would take away from when you want to prepare for an exam is you want to look prepared and competent. So you need to be able to produce the documents that are requested. You need to be able to speak to them. And you also need to be honest and credible. Because at the end of the day, when the SEC comes into your office, you want to make sure that they think you know what's going on and that you got it all under control. That you can produce the documents because you have your compliance program in good shape and you know where things are and who does what. That really helps you build a lot of credibility from the outset. And building credibility helps you kind of get more slack from the SEC. They're going to be less likely to, and I don't know this for sure, but it's been my experience that if you are very responsive and professional and look like you know what you're doing, the SEC tends to give you a little bit more slack when it comes to finding issues because they feel that, they don't necessarily want to put you out of business, but they do want to make sure you're doing things the right way. And if they feel like you've got it handled, that you have enough control over the situation, that even if they find an issue, they know, they have confidence you'll address it, you're just going to come out better in that exam. So things that you really need to do would be to review your last exam letter and make sure that any remediation that hasn't taken place you start taking place, because you want to have a response as to when the SEC comes in and says, last time we were here, and they will say this, they have looked at your past letter, they will want to know, what have you done to fix it? So if you haven't done anything, you need to have a plan as to how you are going to fix it. So just because you don't have an answer or you don't have a great answer, be prepared to have some answer, some plan, and that's definitely going to help you out. So you also want to make sure that you've looked at your compliance manual and you've looked at your Form ADV, and you need to look at it with a critical eye to see, are there issues? Is there something that you haven't been able to update or fix in the meantime that needs to get fixed? Because at the end of the day, you don't want what the SEC finds to be a surprise to you. You want to know, you want to have some familiarity with, if they do find an issue, you can say, yeah, I'm aware of that, and this is what I propose to do to fix it. My advice also is to be truthful when you talk to the SEC. You're going to find, when you start gathering your documentation for an exam, at least in my experience, you will find some problems. Generally, when you have a material issue, it's best to just get it out there up front with the SEC. By being up front, you can establish credibility with the staff, because if the SEC believes you are being open and honest, they're going to be more willing to work with you on a solution. So on the next slide, we have some tips on preparing. This is the introductory presentation. These are things that I think you should include in it. I'm not going to go over this point by point, but this is pretty much a really good way to kind of address the SEC's biggest concerns. But just remember, don't throw it to your marketing people This is not a marketing presentation. You are not selling your firm. You're selling basically your compliance service and your compliance program, so and your operational efficiencies. So make sure that's what the focus is. Moving on to the next slide, talk to your people about how to deal with examiners. Tell them, you need to be polite and professional. You have to make sure that they're comfortable. Don't put them in a cold room. Don't put them in a room that's too hot. Treat them like you would any guest to your firm. You should check in with them at the beginning of the day and the end of the day. Don't be afraid to ask for any requests to be in writing. They may just say, well, we kind of want to see this, but I think it's really important to have everything be very clear as to what they want. And if you don't understand what they want, ask them for more clarity, because you don't want to waste their time giving them stuff they don't really want, and you don't want to waste your time hunting down stuff that they don't really need. Another point is always have your single point of contact, whether that's the CCO or counsel, in any interviews. The point of this is not necessarily to, the point to me is to make sure that you have a nice, clean narrative that's consistent from your ADV to your compliance manual to the operations to portfolio managers. The story should be consistent. And so your chief compliance officer or the single point of contact can help assist with that to make sure that it is consistent. They can also help Goose do what I think of more as SEC speak. So SEC might ask you a question and you want to make sure that the CEO doesn't answer it the way he thinks you should. You need to make sure that you focus on what the actual point is.
Yeah, and likewise with document requests, sometimes people misinterpret what the staff's actually looking for or start volunteering things without necessarily sharing that information with the CCO.
Because one of the biggest things is you really want to get them in and out as fast as you can. So you really want to make sure that you're focused and they're focused. You want to get them their information and get them out the door, because the longer they're there, the more, they may find other things and start asking more questions. And, you've got work to do. You've got other stuff. You've got a firm to run. So you want to make sure that you keep them focused, you feed them the information that they've requested. And this goes for any interviews as well. Answer the questions that are asked and don't volunteer a lot of additional information that may be irrelevant, or you're used to saying it because it's your sales spiel. So, and I also included some information in here. I'm probably running out of time, but about FOIA, which is the Freedom of Information Act. Now, this isn't really discussed a lot in most of these, but I use the confidential requests quite a bit when I'm providing confidential client information, client names, and account numbers and all that. I want to make sure that information maintains its confidentiality. So I do, and I've provided some materials on how to do that. So I think I'm probably out of time. So.
Okay, fantastic. I'm going to go on in the next section. We're going to come back to this because it's all going to circle back to preparing at the end as well. This is the whole examination experience. And right now, we heard a lot of discussion this morning talking about deficiencies and specifically on advisory fee and expenses. So I'm not going to reiterate what the SEC spoke about with regards to the mutual fund share class, but we're going to take some very practical examples, and I want to kind of foreshadow this by thinking about what was on page 10 of the 2020 SEC priority list. And the SEC spent a lot of time this year talking about the duty of care, and specifically they cited that we will examine RAAs and whether they have fulfilled their fiduciary obligations as it relates to whether or not they're meeting the contractual provisions of their advisory contracts. And then further on in the release, the staff commented that we are going to be evaluating the duty of care. and whether or not, and the certain concerns that may arise when an RIA does not aggregate certain client accounts as was disclosed to clients, okay? So this goes into the issue of householding. So for those of you that may use, for example, a tiered fee schedule, okay, which is many people in this room, I'm assuming, okay, I want you to think about what your practices are for householding, okay? And some of the issues that the staff is seeing is that, you know, especially we talk about form over substance, okay? Are we actually disclosing actual sales practices? And some of the things that I'm seeing out there in the field are, you know, we have advisor A, and he or she may be discounting a client's account by saying, look, I'll tell you what, if you give me some more assets, we're going to be able to lower that fee. It's actually part of the sales process to try to accumulate additional assets. Or if we bring in son, daughter's, mom, dad's account, that will yield additional assets where we're going to be able to lower that fee. And I want you to think about in practice, because when the staff's coming in, they're looking at you at the firm level, okay, at the enterprise level. And is advisor A doing one thing and advisor B is doing something else? And do you really have a clear-cut definition of what is a household? How are we aggregating accounts? And I will tell you that there's no requirement for you to aggregate accounts. But if you are doing it in practice, okay, for purposes of trying to achieve a break point, you should be disclosing it, especially in your client contracts, and that's what the commission's going to look at. So what ended up happening is back in April of 2018, the SEC issued a risk alert on concerns of advisory fees and expenses. And within that release, they specifically stated some concerns that, you know, typically we're seeing that fees and expenses as disclosed were not actually the way that they were being calculated in practice. So for those of you that have an investment advisor that has a long legacy, and let's just say 20 years ago, a client happened to sign their IMA, and we haven't asked that client to sign a new IMA since that time, okay? It is likely that in the last 20 years, your fee schedule has changed. And so what the commission might be seeing is that an advisory contract might say that we will be assessing you a fixed fee, but over time, you move to a tiered fee schedule, and now that client is being charged differently than what was on the initial contract. And if the fee is higher than what was initially quoted to that client, there's an issue, and a rebate would be required as part of your fiduciary obligation, because you're overcharging the client inconsistent with the contractual obligations, okay? They also found that, you know, the disclosures were inappropriate. So for those of you that may be, as part of your sales practice, trying to aggregate or accumulate assets in order to achieve that break point for the clients, okay? Are you taking that into consideration? Are you allowing and disclosing to your clients to know about this is how we're aggregating client accounts and defining a household? So, you know, the risk alert went through a variety of different areas, and, you know, what we saw in both the 2019 and 2020 examination priorities is that the SEC is extremely concerned about the disclosure of fees, and, you know, particularly that the contract states one thing, but in practice we're doing another. So these were some of the observations that the staff found, and the slide deck, just so you know, is available on the application, and so you should be able to get this and have this as a reference. But I think that this was the most telling thing of where we are in the examination program today. These various bullet points are based on actual examination requests that I have seen in examinations. And, you know, the kind of questions that you're going to get is, and there's a lot of them, describing what is your actual fee billing processes. And we want to know everything from the identity of who is calculating the advisory fee, who's reconciling the advisory fees, who's sending invoices or submitting the fees to the custodian, who's testing for fee calculations, you know, how are you aggregating accounts? They want to know about your software. They want to know about your billing rates. They want to know about valuations. Are you doing trade date, settlement date? And, this kind of also goes into the various programs you could be using for tabulating your billing practices, because I hate to say this, some of those programs come with what I call the factory or the manufacturer. This is how we're going to set it up. And you might be billing one way and valuing one way, disclosing that in your ADV, such as on a trade date is what is disclosed, but the actual way that the system was set up was settlement date or vice versa. And so you really need to look at how is the billing system configured, which accounts were grouped together, and is there consistency in practice? Okay, and this is a lot of information, and I can tell you I'm seeing different things within the industry that there's not necessarily, this isn't a one-size-fits-all. Some people are aggregating based on residential address. Some people are doing it mother, father, son, daughter. Others that have especially large generational families are going up to grandparents, aunts, uncles. And the question is, in many cases, how do you know which accounts to aggregate? Because only the end investment advisor representative is going to have that information. So it goes down to your compliance program process and the way that you're all communicating with one another, okay? And then what's the terms of the agreement? Very complicated, and I know I went through that rather quickly. So to kind of summarize all of this, we're gonna walk through a case study, all right? So during an SEC exam, the staff learns that Exposed Financial has been in business since 2000. Since that time, the firm has used 3 different investment management agreements, all of which have differing disclosures and advisory fee structures. In the beginning, the founder wanted to charge all clients a flat rate of 100 basis points. Over time, as the firm came to service higher net worth families, Exposed moves to a tiered schedule. But in all IMAs, the firm never disclosed whether they aggregated or householded assets for fee billing purposes, nor did Exposed provide a definition of household. In practice, it was left to each advisor to determine which accounts would be aggregated together. The staff asked to see the IMAs for the oldest client account. The SEC is provided with one IMA, which provides a fixed 1% AUM billing fee. However, when reconciling the billing of the account, the staff discovers that the account is being billed 1.2%. The staff asks to speak with the billing department and inquires why the client is being invoiced this amount, to which they received the following reply. In 2010, we moved to a tiered fee billing schedule, and based on asset size and non-aggregation requested, this client should be charged 1.2%. The staff asked the CCO to pull all reconciliation documents on Exposed fee billing practices for this and 10 other accounts. The CCO replies it may take some time as we just started to reconcile accounts. Okay? So, first question, we're going to do rapid fire on this. I mean, what issues do you see? Anyone? I don't think you want me to walk through all the issues, but I will. Okay, first of all, I mean, clearly there's inconsistent billing practices, okay? And, I think that, one of the biggest concerns that I have in this issue is that we have compliance is just trying to get their arms wrapped around this issue, and there may be times in an examination where you didn't realize there was a problem and all of a sudden you're faced with this. So you have to do some further investigation to see if it's systemic. We're not sure if householding applies here or not. There's inconsistent practices likely because it was left up to the advisors to decide and determine aggregation. And, the actual billing of the client account more than on the advisory contract, as a fiduciary, I'm starting to look at that and say, well, it looks like I'm going to need to rebate that. I've been overcharging this client for the last 10 years. And the new billing process was never necessarily disclosed to the client. And you're going to have this conundrum, well, they received the Form ADV. But many of your ADVs say that fees may be negotiated. And if you didn't do an addendum to the contract, it could very well be interpreted by the client, well, this was one of those cases. Okay? So, what action should Exposed take? And I think, number one, consider, should we be rebating? And when we're rebating, we probably need to be adding in some interest in there as well. And I'm going to be looking at my policies and procedures and doing lots of training. I want to know what we're doing, how we're defining household, do we have consistency throughout the organization? And we've got to make sure that as I go through that risk alert and the different examination questions that are being asked, Could I respond to those questions? How would I respond? Do we have consistency in practice? And if not, then we recognize that we have a gap that needs to be addressed. Yes, sir.
I'm curious, assuming that all the contracts are consistent with the way you're billing, but you're mentioning a couple of times consistency within the firm. So if we're making a judgment call where in this client, the parent and the child, there's really not that much extra work in the child, we're going to go ahead and group bill that. On this other client, no, we actually consider that child to be their own household. We're not going to group them. Are they going to consider that an issue that we're not being consistent?
I'm not the staff, so what I would say is that as a fiduciary, what I'm always struggling with is, if people are similarly situated, are we making that opportunity available for everyone? And what is my disclosure in both the Form ADV and the contract? And so your contract is your agreement with the client. This is what we're going to do, okay? But then I also want to make sure if there's exceptions to this, that I'm notating that as such and stating in the ADV, similarly situated clients are not going to be necessarily treated similarly, okay? And so it all comes down to disclosure. And then what's the actual sales practice? Because the staff will go in interview if they think that there's an issue, the client servicing representative on that account to say, well, why did you do this in one case but not the other? There could be a very legitimate reason, and by no means am I trying to share with you on how to run the business. You have that flexibility, but you just have to disclose your practice and ensure that we're considering our fiduciary duty at all times and the duty of care. Which I will tell you, this has just been my observation. There was more stress on duty of care this year than I've seen in the past, particularly in the examination priorities. Okay, any other questions? Okay, we're going to move on to our next issue, which is trade errors. Mr. Marshall.
Okay, I thought I'd just do a little practical example here. Trade errors are complicated legally. They can be very expensive. So very simple set of facts. 2 years ago, a trade error was made. And so you wanted to buy Apple, but instead you bought General Electric. Apple went up $1.5 million before the error was detected. General Motors went down $1.5 million before the error was corrected. So, there's a $3 million spread there. So very typical, advisor has in their contracts a hedge clause that says the advisor is not responsible for simple negligence, but they are responsible for gross negligence or reckless conduct. So the chief compliance officer picks this up. This is a big deal. It's a lot of money, all right? Do you pay $1.5 million? Do you pay $3 million? Do you notify clients? Well, this is a big deal. So the advisor says, well, I think it was simple negligence, not gross negligence. Go ahead and try to explain what the difference is. It's very subtle, very nuanced. So you're making a really important call in a very subtle, nuanced area. Then you note it in the error log and on your annual review in a very brief way. So now, 2 years later, the SEC has come in, horror of horrors. The exam period covers the period when the error occurred, and the SEC wants to see the error log, and they want to see the annual compliance review, which is very typical. So go to the next slide. So now what have you got here? You've got a big mess. What's going on is that the spotlight has been shined on an area that is very important, very delicate, where maybe the chief compliance officer could have done a lot more work at the time to document how this is all okay and all that. So this is a very uncomfortable position. Can you just magically make it go away? No. The SEC's requested these documents. You can't alter the documents. That would be illegal. Will the SEC just magically drop a request that's standardized? No, that's not going to happen. So did the chief compliance officer do something wrong here? That depends on, number one, was the error caused by simple negligence or gross negligence? A very nuanced, subtle distinction that's going to require a careful review of both the facts and the law. If it's determined that the error was, in fact, something that should have been corrected, how much to correct. Do you give $1.5 million back? Do you give $3 million back? And you better get the business people involved because they're going to write those checks, not you. And then when you make those corrections, you're going to have to notify clients. The law says you have to notify clients, and nobody's, you can't imagine clients are going to just see this money popping in their account, and somebody's not going to raise a question. So you're in a deep hole here. This is bad. So now the question is, should the Chief Compliance Officer retain personal counsel? The spotlight is on. I've told you can't get the spotlight off. It's in the documents. You can't alter the documents. The SEC is not going to drop the request. It's a standard request. So now you're going to have to step up and justify what you did, which was probably not the world's best effort. Is there anything wrong with the Chief Compliance Officer retaining personal counsel? No, absolutely not. Number one, who's going to pay for it? Is the firm going to pay for it? Is the Chief Compliance Officer going to pay for it? Is personal counsel going to appear before the SEC? Almost certainly not. That would be a gigantic red flag. But if you feel that you're in the hot seat and you want counsel and the company will pay for it, there's nothing wrong with that. It's just who's going to pay and how is it going to be managed vis-a-vis the government. How do you clean this thing up? I think the way that you clean this things up, and there's going to be two decision points here. It's not going to go away. The SEC is going to look at this. First of all, you've got to say, do I really have a good set of facts or not? Is it kind of, I was too quick with this and it was really important, I should have done better. And then you've got to go to the business people and say, oh, hey, by the way, 2 years ago, maybe we should have written a check for $3 million, and we might have to write that next month and tell all the clients that we made a big mistake. You're not going to write that check, so you better talk to the business people and see how they're going to react to that. Pluperfect, the SEC is not going to forget about this. Figure out what happened. Is it very defensible to say this was not something that you owed the clients? This was not an error that you owed the clients to correct. Could be, depends on the facts. If you determine that it was something that you should have corrected, the SEC is not going to forget about that. You're going to have hard talks with the business people. Somebody's got to step up and write this check, and that means you're going to have to tell the clients. Some client, when they see money popping in the, first of all, the law says you're supposed to tell the clients about these, but even if you don't, some clients, when they see money popping up in their account, they're going to say, what's this about? It's almost unimaginable you could do this without disclosure. That's going to be embarrassing if it happens. It could create issues with clients. So you've got to get the business people at the table here, and the right thing to do is to do it right now. Don't change the documents. Don't try to some crazy strategy with the SEC to make it go away. Take it on head on, figure out what the facts are, and then do it right. Now, we've talked about writing a check, and by the way, the check is probably $1.5 million. The loss on the position, not the $3 million. The loss, the $1.5 million. You bought General Electric, it went down $1.5 million. You probably also don't have to give the clients $1.5 million that they would have gotten if they went into the Apple, which is what you intended. But even that is subtle, complex, nuanced, and it might depend, is it an ERISA account? Is it a registered investment company? Are there contractual provisions addressing errors? Are there policies and procedures addressed? That may itself be complicated, but probably you're going to be talking about $1.5 million. So should you be proactive with the inspection staff? They're going to find it. They're not going to just say, oh well, huh. You know, obviously this is a big deal. They're going to take it seriously. I would be proactive with the inspection staff. Should you go to the enforcement staff, I would say never, 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 ever, never, never. You're talking to the SEC through the inspection program. If you go to, let them decide. There's no reason why you have to go and just blow your brains out. Let them decide if they want to refer this to enforcement. What credit are you going to get with the enforcement staff at this point when you're already telling the inspection staff? I would say none, and I don't see what benefit there is to bringing them to the table. If you bring the enforcement staff to this table, the odds are they will not just go away. The odds are they will be a problem for you, and maybe you can work this out with the inspection staff without that. But you've got to weigh all these, how bad is the record you've made and all these kind of things. But really what you're going to have to do is figure out what the right answer is, do it. If you can defend it, defend it. If you've got to write a check and notify clients, do it. Deal with the inspection staff on this, and if the compliance officer wants to have personal counsel to advise them, that's fine. Who's going to pay for it? And I would not have that personal counsel come forward unless it gets really nasty, like the enforcement staff comes in and says, we want to depose the chief compliance officer on this. Then, obviously, I would have personal counsel.
All right, one question. Yes, Peggy?
I just want to know, it's not intuitive to me why 3 million is not in scope instead of 1.5.
There's a lot of law on that. The reason for that is that basically, under fiduciary law, the 1.5 million lost opportunity is more speculative. You know, you bought the wrong, you didn't want General Motors or General Electric, you bought it, it went down $1.5 million before you found the error. That's measurable, concrete, precise. You bought Apple, well, who knew what was going to happen to Apple? Even that is somewhat arguable. And frankly, that's very nuanced in the law. And I mentioned all these special accounts because some of the statutory regimes are not quite as forgiving as others on that. And look at your contracts and look at your procedures. But I think probably there's a good argument that the check, if you did it wrong, and maybe you didn't do it wrong, would be $1.5 million, not 3. And guess what? The business people will care. So this is not going to be something they'll say, $1.5 million, $3 million, it's, you know, it's only money.
Now, our last topic for coverage on issues is what I call the oldie but the goodie. You know, performance advertising continues to be top of mind for many firms and certainly has its slew of issues. So Jackie's going to walk us through some of that.
Yeah, so, you know, I don't have a nice, neat little scenario here to go through, because I think advertising is it's a very common deficiency. I've seen it in a lot of exams, and it's kind of like the Wild West because you don't really know all the time when it's going to come up. I would highly recommend that you read the risk alert back from 2017 that talks about the most frequent advertising rule compliance issues. This is still relevant. I understand that there's a new rule that's going to be enacted, but this is still an excellent list of the do's and don'ts of what you should be doing and what you shouldn't be doing. So the SEC is always going to be looking at, well, specifically performance advertisements give them probably the most agita. So, I think one of the biggest issues that you still see are whether you're showing your performance gross of fees or net of fees, and you have to show both. There's just no real way around that. It should be of equal prominence. Another issue that I see a lot is the hypothetical, back-tested, however you want to call it. I kind of think of it as imaginary performance. But if it's not based on real trading of an actual account, if it's based on, it could still be actual activity out there in the market, but if it's not your investment advisor trading an actual account, then it is back-tested, hypothetical, however you want to talk about it. And you do have to provide quite a bit of disclosure to help everybody understand what were the assumptions that you made, because it's pretty easy to be correct now if you can just look back. So that's why I think it is so risky to use. Obviously firms are also cited for failing to have policies and procedures in place, which means you should have some review process. You should have someone looking at advertisements, communications to clients before they go out, just as a reality check, because people get very excited and want to share news, and we're not selling tennis shoes or detergent. We're selling advisory fiduciary services. So that's a much higher bar. I mean, if you hear that these brand new Nikes for $80 are awesome and you're going to run faster, okay, you're out $80. But if somebody's managing your money and they've told you that they guarantee you an 8% return, that's serious stuff. People are very serious about their money, as I think you know. So the risk alert also talked about the touting initiative, where the SEC came in and was looking at what they called touting. And I did see quite a few, we did see that in exams, where we saw things like, you know, use of third-party rankings or awards. And I do see this occasionally where people are like, well, I got this great award, and, you know, and they offered to send it to me, and it's only going to cost me $3,000, and I can have, and it's going to be cited in their publication. And it's like, no, that is not a real award. If you had to pay for it, then it's not a real award. If the award is, the rankings are stale, I would say if they're more than a year old, you know, I would start thinking it might be like fish and starting to smell. So, but anytime you use those kind of awards and rankings, you have to, they just come along with a boatload of disclosure. You have to explain very, very carefully about how those rankings were determined, how many advisors were considered. So it makes sense, so you have some context for what does that mean. You also see still, you know, surprisingly enough, you still see some client endorsements. And sometimes you see that coming in. I've seen investment advisors that might also be selling insurance, and on the insurance side, they'll, you know, have some clients saying, oh, you know, Joe Advisor was the best, and he really made me and my family feel, you know, well taken care of. And even though they're talking about the insurance side of the business, because the guy is still an investment advisor, they're going to get nailed for that. So anyway, there's as I said, they look at that that risk alert, because I think it provides a lot of really awesome examples. I do have some examples on slide 24. You know, things that I probably would have think more as like kind of wiggle or weasel type kind of things, like best in class, because I don't know really what that means. You know, it seems kind of generic, like we're great, but not really saying much. I know I've seen examiners take the firm to task for that, saying you know, that's a little, that doesn't mean anything. You can't include that. I had one built by leading advisors for leading, you know, a system where we build this system for leading advisors, built by leading advisors for leading advisors. Well, the SEC's like, well, what do you mean by leading advisors? Who are they leading? What is the comparison? What does that mean? You know, you need to take it down if you don't have a good answer. We've even seen, like, even in the context of getting a CFEX certification, so that's a certification you can receive for your firm based on certain fiduciary standards. The firm was cited for using that ranking because it didn't disclose the criteria how the firm was judged to receive that rating. So anyway, as you can see then, just on slide 25, we have these are other areas, in the private fund space you see a lot where they talk about, you know, internal rates of, the internal rate of return, those kind of things. Those are basically kind of, you know, made up rates of return. It may have, usually has an aspect of it that relies on the valuation of assets. And because the advisor itself does the valuations for a lot of these assets, it's kind of a misleading thing, because you could say, well, you know, we valued our assets. How did you value them? What was your process? Did you have, you know, were they validated by independent third parties? So anyway, there's a lot of different nuances and difficulties to look at when you're looking at disclosure. So I don't really have a lot of great advice, except to be really, really careful and, you know, try to look at something from the perspective of how is an examiner going to look at it. They're not going to care that you only showed it to, you know, high net worth or institutional investors. They're going to look at it from a retail standpoint. So keep that in mind.
And I think you gave some fantastic examples that, you know, I strongly encourage you to go through when you get back to your shops. I think in concluding today's presentation, Rick's going to spend a couple of minutes talking about approaches to dealing with challenging scenarios, and then we'll wrap it up with just final statements on the risk alerts.
Good. We're very short for time, and I don't want to keep you from lunch. So I've got 10 tough situations. We're only going to do a couple here. Something that comes up all the time, because frankly an inspection is very intrusive. I was thinking of a friend who has a 6-year-old, and every time the 6-year-old goes to the doctor, the pediatrician, the parent asks, "How was the visit?" And the kid says, "Bad." It was bad. And, I ask people after an inspection, "How did it go?" He says, "It was hell." It was hell. Now, I guess I say that because difficult, it's burdensome, they're arguing with us, they hate us, et cetera, et cetera. First of all, most of the time, when I get involved with that, there are two sides to that. It's not really that bad. And it's just a very kind of intrusive process to have an inspection. So try to keep a little bit objectivity. Second point I'd make on these difficult situations is, I tell clients, they say, "Oh, we're going to fight this, we're going to fight that." They say, "Well, let me ask you something. After the inspection, are you going to deregister and you'll never be regulated again?" No. So you want to keep a long-term good relationship with your regulator. So going to war over something in an inspection, even if you win that battle, you may not win the war. So you've got to work through these. And that's the final point to make, is try to find practical ways to solve problems, work things out. Work of compliance consultants, there's been some significant litigation in this area. There is no compliance consultant privilege, either for the internal work of the compliance professional or for external work. There is, unfortunately, unfortunately, it's different. Lawyers have the attorney-client privilege. So there is protected in the Constitution for 1,000 years in the law. Lawyer-client confidential communication can be protected. If you want the work of the compliance consultant to be protected, you've got to make sure you build in advance, proper engagement, lawyer involved, purpose of giving legal advice. You can't just hope at the end of the day that you can somehow keep the work of the compliance consultant away from the SEC. And then finally, probably the most difficult, vexing thing that comes up these days, you're afraid you've got a whistleblower. You've got an employee who's unhappy, saying, "Oh, I think there's a lot of fraud going on here." Now the SEC's coming in, they may interact with this person. This is very delicate. There was an enforcement case a few years ago where a whistleblower went to the SEC. The registrant didn't fire the person, the whistleblower. They didn't cut their compensation. They just reassigned them, took them away from online day-to-day business work, reassigned them to less sensitive work. The SEC treated it as retaliation against the whistleblower and sanctioned the firm in an enforcement action. So you cannot muzzle, silent, punish the whistleblower. I think that if you've got somebody who's disgruntled, bad guy, I'd say two things. One, you probably should have thought of that before the inspection staff came in. Getting in front of personnel problems before the SEC is in your office is always a good idea. That's easy to say in retrospect. But number two, don't do anything to punish this guy, silence this guy. If there's a problem, be ready to address it when it's raised with the SEC. It only makes things worse to muzzle the whistleblower.
Okay, I've got a minute and 23. I'm going to keep you two, but it's going to be an important 2 minutes. If there is a takeaway that I want you to think about, okay, as you go back to your firms, and that is about the risk alerts, okay? You heard Pete Driscoll this morning talking about last year there were 8 risk alerts. I have found this to be almost verbatim to what the examination questions are, okay, that you're going to get. And in fact, in your materials, there was an article that I authored on how risk alerts can help in your next SCC exams. The reason why this is so important is, A, they outline the National Examination Program initiatives. B, they talk about all the different findings, both the good and the bad, that the staff is seeing in examinations. And C, most importantly, when you're going back to your firms, you're trying to say, how do I better my internal controls? Because the dynamics of the compliance program is, We are constantly supposed to be evolving, okay? There are ideas within these risk alerts about how you can constantly improve. What should you be adding to your policies and procedures that have collected dust over the last 5 years, right? And you say, I need to add this. I need to be thinking about that. We need to have standard operating procedures. How are we thinking about, for example, Regulation SP? Were you aware there were 3 risk alerts last year alone on Reg SP? Okay, so I want you to think about that as you move forward. This is an amazing set of resources. We talked about 3 of them on today's panel. And, you know, the goal is to enlighten both yourselves for what you should be doing in your compliance program, bring to the attention of senior management, and I would also say go as far as talk to your investors. This is all about investor protection. And I would really highlight to your clients what you're doing to protect them. And we've given you lots and lots of supplemental materials, so I encourage you to review that. And by all means, we thank you for today. We'll stay afterwards for any questions you might have. Thank you.